I know this is the last panel of the last day, and I was exhausted already yesterday this time, so I can imagine how you feel today. It's like a survival force, so you are my heroes. I hope more will join, but you know. And maybe we try finishing a bit before so that we go in time to the final speech of Paul Dart. But I'm sure more people might join from Grandal, so from the Le Hall. So again, a panel on AI Act, but this panel will be a bit different since we have few people. It will be very much, I think, interlocutory. We can dialogue. Also, I'm so happy. Oh, yeah, sorry, you couldn't hear me well.
Also because I think there are people online.
So I'm very happy because of the, you know, the strategic composition of the panel. I will introduce you the panelists soon, but first let me just tell you. So in these days, many people raised the problems of the AI Act. Today we will try to see where do we stand and what are the chances for the problems to be fixed, right? So we, as a final panel, we will try more for solutions than just for problems, I guess, because it's like in the nature of being at the end. It's like this 4 or 5 panels on AI Act before were like postulating problems, and now we collect in a way. By the way, so first of all, I wanted to introduce our great panelists. I'm very happy to have here Jordanka Ivanova. She's a policy and legal officer at DG Connect, the European Commission, and she's in the group of negotiators for the AI Act. Next to her, we have Vincenzo Tiani. He's a program coordinator of the Brussels Privacy Hub, partner of Panetta Law Firm, and also advisor of the European Parliament, in particular the co-rapporteur of the AI Act, Brando Benifei, on the AI Act. Then we have Ursula Pacle. She's the Deputy Director General at BEUC. Online, we have Olivier Guillot. He's the CEO of Smart Global Governance in France. So as you see, we try to have 2 sides of negotiations, civil society and legal tech industry, to see how, you know, the AI Act might be an opportunity, or what are the limits still on the table. So we will have like this as a round table, very like dynamic, like a couple of rounds, and then your questions. And you know, this is a good opportunity, I think, because we might really see the problems at the table. So I would like to start with some very basic questions to Jordanka. Where do we stand with the AI Act? So what will be the next steps? What are the open issues? In particular, looking at the GDPR, the overlap between AI Act and GDPR, if you think it's an issue, it's an opportunity. So the floor is yours.
Thank you very much. Claudio,
I think it's on.
It's on.
Just try it. Just very close.
You hear me well, and happy to see some faces in our panel. Probably all of you have heard already a lot.
Can you hear?
1, 2, 3. This works.
Yeah, it's just loud.
Yeah. Yes.
Yeah.
Now you hear me well. Okay. So happy to be here with you in this final panel and to discuss the AI Act. You have heard a lot during those 3 very intense days, and indeed this is one of the key initiatives that is now being discussed in the Parliament and the Council after the Commission proposed it last year in April. We are entering into a very interesting phase where the 2 co-legislators, the Parliament on one side and the Council with the Member States, are now consolidating their positions and shaping actually before they try to come up to an agreement. Maybe to briefly brief you on the Council side, we have seen certainly a lot of discussions during the French presidency. There is a lot of work already done with full compromise text they have proposed on the whole regulation, and now they are passing this over to the Czech presidency, which aims to achieve a general agreement with the member states by the end of this year. We also see that with the Parliament, the discussions are very much progressing. We already have a draft report from the two lead co-rapporteurs from the IMCO and LIBE committee. We also have a lot of amendments proposed from other associated committees, and we are in a phase where actually we expect until 1st of June additional amendments from a lot of members. So here there are stakes betting whether we would have thousands, hundreds, thousands of amendments, more than even the GDPR. Some of the most controversial issues where we see both the Council and the Parliament to discuss is indeed the AI definition, the chain of responsibilities, also in the issue of general purpose AI, how actually there is a smooth and fair distribution between providers, users, other actors involved in the value chain, the prohibitions, certainly, and also the high-risk use cases. So a lot of discussions are now taking place and a lot of societal input how actually to improve the AI Act in those critical areas. So this panel and is also very important, and also as well the engagement of all civil society and experts in that discussion.
Thank you very much. Let's start with some spice, with some problems. So I wanted to ask to Ursula, what are the open issues of the AI Act? There are many, and it's impossible to address them all. But let's start to put something on the table.
Yes, thank you very much. Let me see. Does that work? Yes. Yeah. So thank you for this panel discussion and for the question, which is really a huge question. So I decided I wanted to start on a very general level to explain why we are quite worried about the AI Act from a consumer perspective. So I represent consumer organizations in Europe, and why we hope really that the legislators will do what the Commission did not do. And this is, of course, not a personal criticism of Jordanka here, but I think the Commission has really not done a good job in protecting consumers in the proposal they put forward. So the first point to mention is maybe also very briefly that it was quite a disappointment when the proposal was presented in April last year, because previously in the European Commission's new consumer policy strategy of November 2020, the Commission had announced that this AI Act would be a key action, a strategic key action to protect consumers. It's one of the actions listed in these 25 actions of the consumer agenda. And so expectations were quite high, but when the proposal came, it did not even mention the word consumers. So in the entire legal text, the word consumer doesn't exist. So it was quite a disappointment. You know, the definition in Article 3 of the proposal is about users, but users are not end users. Users are commercial users of AI systems or public entities that use AI systems. So this is really an issue, because it means, and I think it is confirmed when you read the text, that the Commission, in my opinion, sorry again, but again we are talking here just on I think on an exchange level, that the Commission did not look at consumer protection. I would say the whole proposal is heavily dominated by a single market perspective, which you can see also by the concept of the proposal, which is built on the traditional product safety legislation concept and the new approach, which is the conformity assessments and the CE mark. So this is the main starting point the Commission took, but did not look at what do we do to protect people, to protect consumers, to protect citizens from the negative impacts that we know AI systems can have, and also how do we empower them to really benefit from these new technologies. We know from our surveys consumers are interested, they have high expectations, but they are also really concerned about the negative impacts on their privacy. They are worried to be manipulated, to be subject to decisions which they cannot reject, etc. So there is a real issue from the general starting point of the proposal. And then, of course, the other issue, but maybe we can come back on that, is how would that AI Act relate to the consumer protection acquis? You may know that we have a quite broad consumer law basis in Europe, which is quite at a good level. There is an obligation of the institutions to protect consumers with high protection measures, that's in the treaties. But there is no concrete clause in the AI Act that would say consumer legislation is not affected, is not precluded by the AI Act, because it is a full harmonization act, so member states cannot do anything better or more protective if there would be a particular risk they come across. They cannot regulate, and I think that's a fundamental point, high-risk applications that are not covered. So if there is, like, we would say maybe a medium risk, let's say one of the issues that we are worried about is connected devices, for example, let's say home assistants or connected toys or these type of things. Member states could not interfere and say we want to regulate that with a higher level of protection. They would be precluded. The only thing the Commission has foreseen is this Article 52, which introduces certain transparency and information requirements, and only for certain, let me say, medium risks, according to the Commission, and that is like chatbots, or it is also deep fakes, and it's emotional recognition, where consumers have a right to be informed. We don't know about what. So again, the Commission highly relies on the idea that transparency and information will do the job, and then consumers can find their way, and there is no risk of something else. And I close with, maybe there is a lot to say, but I'm going too long already. There is also no right to complain. I mean, this has already been very much described, that the whole part of how to get redress if something goes wrong, how to do private enforcement, so how to complain. There is no right to complain. There is no right to redress. What remedies do you have with the consumer? And there is no right for consumers to group together to take collective action, which is also not comprehensible in my opinion, because we just recently had the Representative Action Directive in Europe, which will become applicable in next year. And the DSA, for example, was already, when it was proposed, it was included in the material scope, so consumers can take action collectively if there is a DSA infringement, but not in the AI Act, which I really don't understand how it can come that this is not included. The only expectation is that, again, Commission did not think about consumers and did not think about to make a complementary act to existing protections already. So I close here. I have a lot more to say, unfortunately, but I close here. Thank you.
Yeah, I think it was already a lot on the table. But about the individual rights, yesterday there was this tweet by Mireille Hildebrand. She said, we could add like just 2 rights, right not to be subject to prohibited AI practices and right not to be subject to impact of unlawful high-risk AI systems. I don't know, this would be an interesting scenario looking at the AI liability framework that is coming. But before going to this, you mentioned users and end users and providers. So now I want to go to Olivier. The point of, companies and entities that will need to implement the AI Act, not from the end user's perspective, but from the user perspective. So, Olivier, you run a company, a leader in legal tech, right? How do you foresee the accessibility and feasibility of these many accountability measures that the AI Act requires? What's your view on that?
Thank you very much. Yeah, it will be a long way. Because if we look at, for example, GDPR, 6 years after starting the examination of the regulation and 4 years after its implementation, what we see is that a lot of organizations, public and private, are not ready yet. And not taking into account other privacy or data regulations that have arisen around the world. So we see it will be a long journey to educate stakeholders within companies in order to acculturate them to these new requirements. Probably setting up conferences, setting up trainings, and then when they will have understood what they have to do, helping them putting in place the management system that will allow them to deal with their obligations. That is really close, by the way, in terms of methodology to what they have to do with GDPR. According to us, it's really a concern of change management, acculturate people to these new obligations, help them understand. They will probably need to be accompanied by advisory firms in order to put in place, because in fact, nobody has put nothing in place at the moment, apart from some frameworks provided by US firms. So a lot of educational work to help them, and then they will have to probably encounter again the same problems that we encounter when we start a new digitization of a process, meaning technical difficulties to maybe first identify where all the projects, the AI project, human aspects of reluctancy of people, considering compliance as a constraint and not or as an opportunity to create a really trustful ecosystem. Budget concerns, because again, it's new obligations, but the budgets for compliance do not rise as much as the obligations. Just to give a global context, you have other obligations for companies this year and next year, like European taxonomy for ESG. So they've got a lot in the plate, few budgets and few trained people in order to face these obligations. So it will be a long way.
Yeah, it will. Thank you. Now, I wanted to ask to Vincenzo to share a bit his view, because he, as you understood from the presentation, he has many roles. Like he's a partner of a law firm, he's a researcher, but also he helped the European Parliament. So, from your perspective, looking at the tools, the protective tools of the AI Act, the enforcing mechanism, what do you think? Can we be optimistic? Should we be worried? What's your view?
Thanks for the question. Thanks for the brave people that are here the last day, the last panel. I mean, when you read that the GDPR, you were optimistic that everything with enforcement would have worked. We have seen so far that after 4 years and 6 years after the publication of the text, that's not been the case. And we know that for sure because the EDPS and the EDPB are organizing an event next June, 16 and 17 June, just to address the problem of enforcement. So definitely it's still a problem. So from the data protection perspective, I would say that for sure the AI Act poses more complexities to the table. Why that? Because it's not just about personal data, of course. It touches upon every sector we know. And then, therefore, he asks for several authorities. So we have national authorities, we have a market authority, we have the notified body. So instead of having just one authority, we have several bodies to take into consideration. And I mean, it's not that we don't need those, but for sure it will be very complex, especially for small, medium enterprises. That's why in the draft report, so the one presented by the two committee, IMCO and LIBE, there is this amendment that basically gives the Commission special powers. Not in any case, but basically to deal with just not big tech, but everyone is thinking about big tech. So the amendments basically will give the Commission the role of European enforcer, and when there will be a widespread infringement at EU level, or an inaction by one member state with an effect, with an impact on at least 2 member states. As we know, with the GDPR, we've seen, let's say, a lack of enforcement, especially because of this bottleneck we saw in Ireland for different reasons. Reasons that also an interesting report of Brave in 2020, where Brave analyzed the structure of all data protection authority within the EU, and this is something that we still have to deal with. We have in the Data Protection Authority, we don't have any technical personnel officials. So at the best case is Germany with 100 people in the staff out of 800 people. But for example, if I think about Italy, I think there are less than 10 people on a staff of 150. So there is a lack of specialized personnel, technical staff, people that can follow the data, that can gather inputs, that can gather evidences to build the case. There is a lack of human resources. There is a lack of economic resources to go on trial. So this is for sure an issue, and this is an issue now for the GDPR. Has been an issue so far, and will be an issue as well for AI Act, especially if we have also several authorities involved, and we don't know which authority if we will have new authority, if the data protection authority will be the national authority. We don't know that. So for sure. So this idea to avoiding repeating the past. And giving the Commission these special powers only for, let's say, bigger cases with huge infringement effects on the European citizen. I don't know if it's the magic wand, if it's the magic solution, but I think it's something new. We can discuss it. Also because the European, we don't have just the AI Act. We also have the DSA, the DMA, the Digital Data Governance Act, Data Act, and we've seen that the Commission is gathering lots of power. They have the resources, but still they will need to hire more people, more specialized people. I don't know how many buildings we will need to have all these people in Brussels, but I think it's needed. So I will actually like to discuss later if this is a good solution with both parties. Just to close, I think another important amendment is the one to Article 59, where basically the DPAs, the data protection authorities, are called upon to cooperate closely with the supervisory authority when they are not the supervisory authority design. Why is important? Because it means that the Data Protection Authority still have an important role. They are so far the authority that have the more experience in dealing with data, in dealing with this kind of infringement. So even if the member states doesn't want, and it's comprehensible, that the Data Protection Authority gathers, let's say, all this power even on the AI, I think it's important to put on the AI Act that in written words that they need to be consulted.
Thank you very much. I think the point of enforcement was so much like a side project, a side topic in this last day's discussion. So I think this was something very important to highlight. And also, it was quite funny because in the first interventions were a bit like the Commission was a bit, not so good. The Commission was, and then the solution is to give more power to the Commission, probably, because the amendment that Vincenzo was describing, if I understand correctly, is to give to the European Commission the role of enforcers, perhaps with a special unit on the AI Act, like it's for the competition law, basically. Okay, so Commission. So let me go back to Jordanka. Just if you can, comment on the many things. A rapid summary is the hierarchy of risks, transparency and information that we don't know exactly how to do that, and also it's a limited tool for emotion recognition or for such important things. There's no individual rights, no collective actions, etc. The floor is yours.
Well, a lot of criticism, indeed, and some maybe I will try to explain and address because these have been part of them thinks that they have been considered in the decisions taken by the Commission as a collective authority in the end, proposing this act with a lot of services involved, including also certainly the one responsible on data protection, on consumer protection. It's a lot of collective thinking that has gone there and important decisions. Now, some of the key considerations that have been taken. First, the AI Act should not overlap or repeat with legislation that is already at stake. We don't need to just put again same rights that are protected in existing legislation just because we think that that legislation is not effectively enforced there, because that can create competences issues, complications, and that's not the purpose of creating more complexity, inconsistency, and legal uncertainty also for providers, companies, but also even for people to whom they have to address themselves. And then the other big thing is that the AI Act is indeed just one puzzle in this big, large existing legislative landscape that we already had. That's very correct what Ursula said, because we indeed have consumer protection legislation. It is there. We also have data protection legislation. And the AI Act, what was meant to do is just to fill already existing gaps that we have tried to identify, or to make those rights that are given to data subjects, that they should be able to object to certain processing, or they should be able to get compensation under consumer protection law, to make them effective when AI is used. So it means that we should not be as individuals deprived or harmed just because AI is used, and the organizations who are already responsible to comply with their obligations and protect the rights should have the availability of the tools that are already checked in advance. They are sufficiently interpretable, transparent, they are sufficiently tested for biases, they are sufficiently accurate that they can really be sure that they are respecting their existing obligations. And certainly the AI Act is not repealing anything that is given as rights and that is existing as protection already to consumer or even to safety. It is without, we often use in the legal text that word, without prejudice, but certainly everything that is already there applies. We don't repeal rights, or we don't decrease at all the protection. The objective is, on the contrary, to increase it. And then when it comes to the word consumer, now I agree with you, it's indeed mentioned only once, if I remember well, in one recital, when we talk about that the objective of this legislation should be to protect fundamental rights more broadly. And then you have in these recitals enumerated the right to consumer protection, which we all know is a fundamental right, but we have maybe more than other important rights as well, covered by the EU Charter, the right to privacy, data protection, human dignity, freedom of expression, physical and mental integrity, and many, many other rights. So that's why in the legal text and the provisions themselves, the objective is ultimately to ensure this high protection of fundamental rights. And for conciseness, it is only the word fundamental rights that is covered, because that's the broader category, but that certainly includes also the consumer rights, because we fully agree. Then it should be also the consumers who are affected. They can be users, if we are in a business to consumer context, of products, because we certainly also regulate AI embedded in products, so they should be protected if they are the users, but they can be also just the persons who are affected by the use of those systems, for example, in a context of employment, or when a public administration is using those systems. So they would be just citizens and even not consumers. So we really aim to cover even a broader category than consumers, but certainly also protect the consumers. I think maybe when we go a bit for this, I'll try to not to take too much of the time, but I just want to focus a bit again on the classification of the risk use cases and the fact that indeed there might be other products, actions that are currently not classified as high risk. One key consideration when we looked at what should be now put in the legal framework, because we tried to give a more legal certainty this time to operators when they would be actually falling and when they have to comply with these requirements, because we have seen that having very complex risk assessments with different criteria can lead to inconsistency, legal uncertainty for operators, but also in the end less effective implementation if they are not properly done. And not to say also a lot of cost and burden also for companies, because then we would not have just a small group of operators who would have to know and comply and invest their resources in the compliance, but they would have to go to legal companies just to get the advice, am I there or am I not? So that's why we try to find this balance between innovation, legal certainty, and at the same time sufficient protection, so we identify those use cases and we make them really work and effective for those really contexts where we think there are significant adverse effects and impacts that can occur to fundamental rights of people, also to their health, safety. But we have also considered other criteria, for example, whether the existing legislation is already effectively mitigating those risks. And I want to repeat again here, the fact that it is not a high risk now does not mean that it cannot be added if there is a demonstrable case and evidence and consensus that indeed that should be added there. Now there is still an ongoing discussion to really set this high risk of use cases, and a lot of amendments also still coming from the Parliament. But in any case also we should not forget that there is also still existing legislation that protects to a large extent also consumers, because we have product safety, and this is just one additional element with the AI Act, but we have a very robust key of product safety that is already existing, safety net, sectoral specific regulation, and of course if there is a need, there can be even more specific considerations also in different sectors, but also addition in the high risk list if needed. And I think maybe, I don't know whether I should cover now the enforcement, but maybe I'll leave it for later so I don't monopolize.
Yeah, thank you so much. So I think we can summarize your points. First of all, I mean, trying to reach, to balance innovation and protection. You were trying to give some clarity, foreseeability, and so on. Also, the sandbox is a topic that we don't have time to address. And then another point that you raised, the first one, but you raised it in different parts, is that the AI Act is without prejudice to existing legislation. And so this is what I would like to ask to Ursula. Looking at interplay between the AI Act and the other existing legislation, Jordanka mentioned the fact that Unfair Commercial Practice Directive and other sources are already covering and protecting individuals. So we didn't have to reinvent everything with the AI Act, right? And BEUC has a long tradition of research and activity on the Unfair Commercial Practice Directive and other consumer laws. Also, looking at the role of the European Commission as someone that updates the high-risk list, this is the same in the AI Act and the Unfair Commercial Practice Directive. So, Ursula, is this a good model? Do you see a good overlap between the Unfair Commercial Practice, the AI Act, or there are some gaps, some inconsistencies?
Yeah, That's a good question. Because first of all, I have to say there is no without prejudice clause in the AI Act, Jordanka. This is one of the problems, right?
It's in the recital, yes. It can be added. We fully agree. It has not been the intention.
I don't think there is any without prejudice clause. So we have done research on that. So it's for the legislators, hopefully, to help us out. Because we have seen cases, and it's not the first time, that the European Court of Justice would go and interpret really expressly what is written. We have seen it in the Product Liability Directive, for example, so this can really hit hard. So we must be very careful with that. But the point is, there is a lot to say, but maybe starting point would be to say, we have the Unfair Commercial Practices Directive, right? That's correct, which in principle defines the standard for what is unfair and what is illegal commercial practices. It's extremely broad. But this is, on the one hand, a gift. On the other hand, it's a problem. It's a problem because those who have to enforce that law, the courts and the authorities, they need to know what that means when it comes to AI systems. And this is exactly what we would expect from an AI Act, that it tells what is fair, what is illegal, where are the red lines, and what needs to be done in a certain way, so obligation and requirements. And we cannot rely on a very, very horizontal act that was written 30 years nearly ago, where there was no AI system on the radar. So what we expect from the AI Act is to be a lex specialis, to really regulate and to protect effectively and efficiently. And if you leave it to the UCPD, and I quote the Commission from the explanatory memorandum, because otherwise there is no trace how the Commission thinks then consumers can be protected, it says something like, I have the sentence here, other manipulative or exploitative practices affecting adults that might be facilitated by AI systems could be covered by existing data protection, consumer protection, and digital services legislation. So could be, could happen, could be. So what I mean is that that's exactly what I mean. There is no thought through coherent approach to how do we protect consumers from the risks of these systems. And that's really a problem. So again, you can decline it through. You would then have the CPC authorities, the consumer protection authorities, who are not equipped, who are not, they are not really made to deal with AI systems. So, and I think it's very welcome what the European Parliament is doing now to really look at the enforcement and at the governance structure, and to say, for really the big cases, there must be, okay, let's say the European Commission will see, the proof will be in the eating of the pudding, whether that is a good idea or not. But I hope that they would have experts, and that way would have the resources. But giving this to the CPC authorities only, leaving them alone in this endeavor, I think that is much too much, and it's not coherent with what I would consider to be a high level of consumer protection. And then maybe just a word on the red lines. So we have, that's where your question was, Gian Claudio, about the prohibited practices, right? And I think there is also, again, sorry, today I'm really conceptual. We need to understand that consumer protection cannot be done by transparency and information. In a digital economy that is complex, where you have the black box of the algorithms, you cannot say to consumers, this is the information and you will make the decision and you will not be manipulated because you're a circumspect and intelligent and smart person and you will do the job. So this is not what we need. We need some clear red lines, and we welcome, and it's a great thing, Commission has had the courage to say Article 5, this is prohibited, this is prohibited. That's very good, but a lot that should be prohibited is not there. I think it's really important to not do with information and transparency, but to say this is prohibited, and then give the obligation to the member states or to the Commission to enforce that. This is the way forward to protect people in the digital economy. I don't see any other effective way. So what we have in Article 5 is a good starting point, but it's far not enough. It is only for physical and psychological harm. That's this sentence that I just read. I think what the Commission says is economic harm. It's not in the AI Act, it's not prohibited. I mean, if there is risk of economic harm, it has to be dealt with by consumer legislation. Or maybe if it's a data protection issue, it could even be the GDPR. So it's only that. And then what is really important, and this is also interesting, and a shortcoming of the AI Act, it is only if the AI system intends to harm, which is crazy. If you look at the advances that we have already in European law, in consumer law, is not, you have not to demonstrate that it is an intended purpose, but it is a practice that is likely to have that consequence. And that is much better, of course, in terms of also for the enforcers. So the standard in consumer law is higher. And that is also the standard that should be used in the AI Act. Then, of course, you have social scoring by commercial entities is not prohibited. We think it should be prohibited. You have emotional recognition, which is a high risk, but it's not prohibited. We think it should be much narrower what is allowed. In principle, should be prohibited. We have, biometric recognition in public spaces, but it should be prohibited to be done by commercial entities. So there is a long list, and last not least, vulnerable consumers. That is something, I don't know who attended maybe the opening session, but there was this really interesting panel that Gian Claudio moderated. So the question is, who is vulnerable in an AI-driven market? Who is vulnerable in the data economy? And our approach there is we need to overcome the old-fashioned concept that we have in some legislations to say vulnerable people are those who have specific features. It's like the old or the young. It's those that have physical infirmity or psychological infirmity, or it's the credulity of children. These type of things, that's not enough. We need a broader understanding of vulnerability. We call it a universal state of vulnerability. If you're exposed to these very sophisticated and not comprehensible and not even realizable techniques that will be applied, that will manipulate people. So the vulnerability that you have in the prohibited practices is still very narrow. It's about, I don't know, age and children, etc., etc. And it is only if it is intended to harm those vulnerable people. So let me see who is going to do an impact assessment to say our intention is to harm vulnerable people. And that's then the category that you can cover. So a lot, I mean, it has been very well already identified in academic writing that these Article 5 categories, the first ones, they are not going to help anybody because they're not, it's the really totally extreme cases that, probably will not be very relevant. But I stop it here.
Yeah, I mean, many points. Just fact-checking about what we said, without prejudice. There is without prejudice for sandboxes. So, exactly. So not for.
So
not
that's
for,
the other way around.
Exactly.
So that's not what we are talking about.
Exactly. So, but what else? Yeah, you touched upon great points. So basically, the lessons from consumer protection law is that transparency is not enough. Was like a neoliberal model in which transparency was thought to be okay, but no. And also the intention, that there's no intention in the Commercial Practice Directive. There is something in the AI Act that intends to. But before, opening to questions, I still want to hear from Olivier. From a legal tech perspective, you were one of the companies trying to automate DPIA. Of course, it's not easy. It's still, after 6 years, DPIA, it's something that we still need to understand. And I was curious to ask you, would it be possible to automate, at least in part, the AI Act? It would be a paradox because there are human oversight things, but the many accountability thing, from a compliance perspective, let's say that, from a compliance perspective, do you see that it's something that you can do, or that we can have like ways to deal with? If you can be brief, so we leave time to questions later.
Yeah, sure.
Thank you.
Yes, it's possible to automate a part of it. First, to put in place continuous monitoring using data discovery, for example, to be sure that the data that is supposed to be used with AI is stored at the proper place. Also use anonymization rules in order to secure the data. And so it will reduce the pain for the PIA if you put strong rules at the beginning. And as for the PIA, yes, it would be possible, like as for GDPR, in order to put in place collaborative processes in order to collect information to detect AI algorithm at risk.
Yeah, thank you very much. Now, I mean, before opening to some questions, and there are so many points that we could address, but something that I want to make sure to know is the future of the future steps of the Act, of the AI Act. So, looking at the European Parliament, the two co-rapporteurs had this report in which they tried to address the points that they want to raise. Then there will be the amendments, and then there will be the vote, and then there will be the trialogue. What can we expect in terms of timing, in terms of content?
In terms of calendar,
Yeah.
yeah. So now, first thing I would like to point is that this is something unprecedented to have, two committees both responsible for the for this regulation. So that's why it was even besides the side committees that gives their opinion, but the Libe and INCO are the ones that had to work together. So it was a different kind of work, because of course you need to put apart your your personal thoughts, your party thoughts, and then trying really to from the beginning to find the balance and the compromise. So this means that already the draft report combines the views of both two different parties and two different committees. That said, so the first deadline is the 1st of June for the amendments, so next week. By the end of October, the idea is that IMCO and LIBE committee will go to the vote. In November, there should be the plenary vote from the European Parliament, and then so in December, with the Czech presidency expiring, there should be the start for the trialogue. I checked on Wikipedia who are the next presidents of the council. They are Sweden first and Spain then. We'll see if I think that we'll need both of them, because I see I don't think there is the same common approach, common intent that we saw with the DSA, DMA, DGA that were, I think, since I started to follow the European Parliament, European Commission work, perhaps they were the most quickest, pieces of legislation in the digital sector we could see. So I think there will be more room for discussion, especially. So, for example, the IMCO committee will propose in the amendments a human rights impact assessment. That of course could raise some eyebrows from the council, and for sure even changes to Article 5, for example, to remote biometric recognition, and other. I don't want to. Yeah, I think we don't have time, so I will give to Q&A. That's the calendar. I think that these will be the main issues. I want to assure Beuk that there are many amendments coming. So for emotion recognition, even deepfake, for sure. We don't think that it's so. It's quite complex, deepfake. So it should be put in high risk. So not just about transparency. Emotion recognition as well should be prohibited, and so on. So I will, I will leave to the Q&A.
The intention also, I guess. The intention.
Yeah, exactly. Actually, also even in the draft of the first draft of the council, the intention part was deleted. So even, for example, I mean, normally it's that you have the parliament more on the fundamental rights, and you see more the council on the innovation side. I can see there were many amendments from the start from the council that took into consideration the fundamental rights part. So even social scoring, not just for public sector, but even in the private sector, and many others. I will leave to the Q&A because I think we are running out of time.
And also the vulnerability part. I think there is something referring to sensitive data.
Yeah, even the council added not just the sex and age, but even more cases. So I think so. There's some room for discussion, but I think we have some common points.
I forgot to say that another role of Vincenzo is to be a journalist, so he did a good summary of this. Now, I think Jordanka would like to reply, but I would like to see if we have some first questions. Yes, please.
Thank you for the interesting discussion. I have one question concerning corrective measures or consequences of infringement of AI Act. Let's imagine that a company developed AI system using so-called ill-gotten data, so data used without legal basis. Some researchers think that order to stop using data or order to delete data is not enough to protect rights and freedoms of subjects because so-called algorithmic shadows. It's really interesting to know your opinion about that because some offer to use deletion algorithms like FTC approach to Evernote and Evernote and Cambridge Analytica cases. But some researchers think that it is not practical approach. What do you think about that?
So I think you might be in the position to reply. Corrective measures. What do you?
Yes, no, that's a good question. I think in general, in the AI Act, there is a requirement for data quality and data management. As I said, it applies on the top of already what we have in GDPR as data protection legislation, because the legal basis is there, so we certainly don't interfere with that legislation that exists already. But you are right that in the end of the day, when the data is used for developing an algorithm that can be actually based on data that is illegal, we require the provider to describe the provenance of the data, to make sure that it fulfills also the requirements of good data quality and data management procedures, to document all these considerations in the documentation. And then there are obligations to take corrective measures if it turns out that the algorithm actually has been developed in a way that is posing risks to fundamental rights, whether it is in the development phase or whether it is in use. So it's not explicit now in the AI Act that such corrective action could actually also cover, for example, the deletion or the recall of the algorithm. Certainly market surveillance authorities can ask the algorithm to be recalled if it has been in violation of the law. But I know also for the practice of the FTC, and that's an interesting maybe thing that can be discussed and added as a specific corrective measure.
I saw there was another question there, unless you wanted to add. No. Okay.
Hello, Jakob Zanold from the University of Vienna. I have a thesis or an idea, having heard many talks now on AI and also your excellent talks. And I just want to hear your opinion on this. Because in my opinion, there are high expectations regarding the AI Act. Having heard also your excellent point, Ms. Pachl, on the consumer protection aspect in the AI Act, is it, or was it the idea that the AI Act sort of complements the GDPR, which is on data protection? Also, there is a protective framework on one fundamental right, and now we have the AI Act, which is sort of a additional protective framework for all other fundamental rights in the digital sector. It appears that there is expectation such as this sort of swirling around. And maybe if we, as far as I understand, you made clear that it is sort of an additional complementary legal framework that sort of connects the protective framework already in place with regard to special software, special algorithms. and if we could make it more transparent, that this is the purpose of the AI Act, and then focusing on this specific purpose. Also with regard to the definition of AI, which is also not so clear in the AI Act, that many expectations probably would be lowered, and then there is probably more acceptance on the AI Act proposal. What is your opinion on this? Thank you.
Yeah, great. I try to summarize. So your theory is we take the Charter. Article 8 is protected by GDPR. The other articles, other fundamental rights in the digital sector should be protected by the AI Act. But the expectations were not exactly met, if I can summarize well your yeah? So who wants to build on that?
I can start.
Yeah.
I don't know. This is a nice idea. Let me put it like that. But I also need to clarify. So, what do we expect as consumer organizations, right? What we expect is a high level of consumer protection, effective protection. Now, okay, thank you. Do you hear me? Okay, very good. So a high level of protection is not only our expectation, by the way, it's an obligation of the European institutions according to the Treaty for the Functioning of the European Union, right? So now the problem is that we have consumer legislation, but it is not specific enough. It is not giving the necessary rights that you need in an environment, in an economy where you have these AI-driven practices, commercial practices, right? So we need additional rights. We need obligations of these people who use these new systems in order to protect consumers effectively. Some of this can probably be done by the existing consumer law acquis, but that I see that rather as a safety net, right? For example, in unfair commercial practices, you have a definition of fairness, you have a diligence threshold for the companies, but it's very general. But if the lex specialis that I see the AI Act to be does not, protect consumers on this, specific practice that you look at, maybe the safety net of the consumer law acquis could come in. This is how I see the distribution of roles between the different legislations. But I think in general, we have this problem now that we have so many digital acts. So we have, I don't start the whole list, DSA, DMA, AI Act, DA, DGA, whatever, that it's hard to understand. And this is what I really think Commission must do, to see what is the role of consumer law in relation to these different acts, and how do we have, first of all, the necessary clarity that these acts do not preclude consumer law, because that is what is not clear at all in some of these acts. And actually the prejudice clauses, they differ from each act to each other and to one another, and in the AI Act there is none. So the Commission, I think, needs to be a bit more coherent and holistic in its approach to these type of things. But I mean, that's my interpretation, how I see the different roles of the different pieces of legislation. But it's high time to understand the interconnections and also the specific role to protect in a specific market with specific technology. I think this is what we expect that the AI Act does, and that the enforcement authorities are equipped to do effective enforcement. Thank you.
I can add something. Yeah. It's true that, of course, we have several legislations, but for example, in the GDPR, we have with Article 80, the provision that says, okay, you can basically have a class action to deal with to protect your personal data. That's not the case for every piece of legislation we have. So we can add something. We can add more protection, I would say. Another thing is that I've seen, again, it's true that we have several pieces of legislation, but it's also true that, I don't know if it's because the GDPR has not been enforced as we would have loved to see, but even in DSA we have found several provisions on data protection, on privacy, for example, on ads to protect children and so on. And I mean, even just with the GDPR, it should be easy to address that kind of problem. But I've seen that the legislator needed to push harder and to remind companies that there are some some moments that need to be underlined, and that was the case, and the same is in the DGA and our other examples. So, yeah, in theory, it should be like that. So, with different legislations, but in practical, it's not the same. That's why I understand completely the need to be more explicit in the AI Act. And that's why there will be in the amendment some, for example, the human rights impact assessment. Even in the DSA, for example, it was something new, right? So the bigger platforms basically, since the platform can't, just work on a single post when it has to be deleted, So after a year, let's say, they will see if the platform was used against fundamental rights, against the users, and so on. So it's something that is a new principle, and I think it should be used even here with a human rights impact assessment, so something even more protective.
Yeah, I think a good point. In particular, there will be now a totally new panel about risk assessment between DSA, GDPR, and the AI Act. They have, and also the human rights impact assessment. What is it? How we do it? And so on. And there was a panel 2 days ago, so you can go back to the recording. We are going to conclude. I want to give you time, to give us time to reach the other. But maybe Jordanka wanted to say some final thoughts.
Well, I think for the sake of keeping us not too long enough, I just wanted to react maybe on the point with the prohibition. We agree that they are phrased in a narrow way. That has been a long discussion. Maybe you have seen earlier versions where they were a bit broader. The intention has been that in the end, there is also a lot of legal uncertainty also for how those provisions are implemented in practice, and a lot of consequences that might not have been fully assessed, whether that might not in the end prevent something that is beneficial in a way. For example, let's just give us an example, the emotion recognition system. I think we fully agree that that is certainly very much intrusive. I'm even questioning whether that would be allowed under existing data protection law in many circumstances. But there could be also beneficial applications. For example, if autistic people use those kind of tools, or people with other visual impairments, so you use them for some medical treatment. So having complete prohibition is also very sharp, and we have to assess it carefully so we don't prevent anything that goes beyond to the really harmful use. And here I also want to react to that point, because it's for the intention that you have to inflict the harm. That's I know the prohibitions are phrased in a complex manner, but nowhere it says that the intention should be to inflict the harm. The intention is only related to distort the behavior of the person, which means to manipulate it, but then the harm might be intended or unintended. So it's phrased in a more flexible manner, where you could also have effects of those harms that occur. And here we also agree a bit with the changes that have been done, highlighting that then even the effect of the manipulation can happen even without it is actually intended. But already it has not been so limited phrased, I wanted to highlight, because it would be indeed ridiculous to wish someone to behave. And maybe just a final point, yes, indeed, the prohibitions will be one of the most interesting subjects. There will be, of course, a careful policy assessment that will be done by the co-legislators. The Commission will be an honest broker there, but also just for our role as enforcer, because it's true there have been now a lot of suggestions to centralize a bit more the enforcement. I heard here that the Commission has resources to do that, but actually that's absolutely not the case, because, taking the enforcement from national level and then bringing up at European level, yes, for the DSA, there have been a significant now amount of people that are going to be recruited, but then there is also an additional funding that is needed for that purpose, and certainly for the AI Act, there was nothing, neither was for the DSA. And what they are doing, they are charging the very large platforms to recruit those people. So what that would mean also for the AI Act, we'll need now to be able to recruit more than in my unit. We are around 6 policy officers dealing daily with conferences, work, and so on. So to have really an effective enforcement, we have to provide the Commission with the right resources, and that's really the job of the co-legislators to do it, because otherwise, if you task the Commission with such an important role, that's really the crucial effect of all the rules we are talking about here. We might need not have the perfect rules, but they really have to be effectively enforced. And if that's failed with the way the resources are secured, that will certainly not lead to the outcome we all want. So with that, I stop.
Yeah, it's fascinating that the trialogue started, but basically because she said this amendment is not the best, but this other. Okay, thank you so much. I think it was very, very inspiring, very great way to celebrate the end of CPDP and GDPR Day. So see you next year, and thank you very much to our speakers.